Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Lior Samfiru, partner at Samfiru Tumarkin LLP. Before we get to your emails and phone calls, Lior, tell us why everyone needs to watch this show.
Well, unless you're retired, not working, not planning to work, employment law is relevant to you. We spend so much time at work, more time at work than doing anything else. And most people that I know are not aware of their rights, or their misconceptions that people believe. We've talked before about how many misconceptions there are when it comes to employment law, and misconceptions are very dangerous. You may believe something to be true when it's not, and because of that, you'll walk away from rights that you have, and you'll walk away from entitlements that you're owed. So on this show, we try to demystify this area of employment law and tell you what you need to know if you're an employee, if you have rights, if there's a workplace problems. It's not always going to be wonderful at work. Sometimes there's going to be conflict, questions. Maybe you're facing an ultimatum. Maybe you lost your job. Well, we'll cover this on this show so that people know what to do, so that people are empowered, that the law is there for them. And I think that's very important. And let me give you an example this week of a situation that came across my desk that I think puts all this into context. I spoke with a gentleman that, by all accounts, for about 18 or 19 years has been a model, an exemplary employee. He's worked with the same job, had a great relationship with his employer, planned on retiring in this position. Well, very recently, his boss retired, and a new manager came on board. And right away, things changed. He immediately started feeling that this manager had it in for him. He was being mistreated and bullied. He couldn't do anything right. And he certainly got the feeling that this manager wants to push him to retire so that someone else could be hired instead. He did speak to the owner of the company, who was not really that involved. Nothing had happened, and he started suffering from anxiety, and he was on medication because of this situation. He finally called me, and his question to me is, well, what do I do here? So let's be very clear, Dana. We all have a right to work in a harassment-free work environment. That is a basic right that we all have. I don't care what position you have. I don't care where you work. You have that right. So what I told this person is, well, if he wants you, your boss wants you gone so badly, let's give your boss what he wants. Let's get you out of there. But in the eyes of the law, that will be considered a termination of employment, not a resignation, and means for him that he's going to get paid severance, potentially as much as 24 months' pay after all the years that he's worked there. If your employer puts you in a situation where you really don't have a good choice but to quit, it's not a resignation, it's a termination. We call that a constructive dismissal. So I'm going to get him out of there with compensation. So this is an important message and reminder to everyone out there. Number one, you shouldn't just tolerate harassment, ever. Talk to your boss, give him an opportunity to fix the issue. If nothing has happened, let's get you out of there. Let's get you compensated so that you don't continue suffering. You have those rights, and they're very important.
Okay, if you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call, Lior. These calls are coming in from your radio show across Ontario and Canada, where you take live questions from listeners. Let's take a listen.
My wife is 60, going out on a surgery, so she's on medical leave. And then when she comes back, I think they're going to put her on EI because there's no job apparently for her to come back to. She worked at a company for 16 years. It sells. The franchisor has taken the franchise off her boss's hands. I just want to know, like, roughly what would she be entitled to after working there for 16 years?
16 years.
It's a long time, and I think she certainly deserves better. And let me, before we even talk about what she's owed, let me tell you why this situation is wrong. If she goes off on a medical leave, the only time her employer can assess whether they have a job for her is when she's ready to come back to work. By jumping the gun, by saying to her, we know already that when you're ready to come back to work, whenever that is, we're not going to have a job for you. They're jumping the gun, and that could be a human rights violation. They're letting her go because she's sick. They don't want to consider bringing her back. So for our viewers, it's important to know, if you're sick, if you're off work, that's fine. You remain an employee, and your employer has to make all efforts to bring you back when you're ready to return. Now, in this situation, if they're not doing that, there's human rights damages owed. And beyond that, of course, she is owed severance as well. So that's obviously a big question. How much severance is she owed after 16 years? I can tell you, I really could, but I want to show you how you can find out, how anyone can find out in seconds how much severance you're actually owed. Let's take that information and go to our severance calculator, which you can find at PocketEmploymentLawyer.ca. And when you go to PocketEmploymentLawyer.ca, when you use the severance calculator, in seconds you can find out how much you're owed. Let's use that for this person. We know she's been there for 16 years. She's 60 years old in a sales role. We know, based on that, and you can see on the screen right now, she's owed as much as 18 months of severance. 18 months, that's what she is owed. And it's that easy and that simple to find out and to calculate how much severance you're owed. That's over and above her human rights damages that she could be owed. So for anyone out there losing their job, first place you go to is PocketEmploymentLawyer.ca.
Okay, let's take a short break, and when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will delve into the 5 facts employees should know about their contracts. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is answering questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have lots of calls and emails coming in, Lior, but before we jump into those, let's talk about today's main topic, 5 key facts you should know about employment contracts. And the first one may be very surprising to many people, and that is you are likely better off not signing an employee contract.
I know it's surprising, and that is the case. Now, keep in mind, Dana, we're talking about employment contracts, job offer letters, employment agreements. They're all the same. And for an employee, you are far, far better off never having signed one of those documents. You are better off to have a handshake deal with your employer, or frankly, go for a drink at the pub and write something on the back of a napkin. That is also better than having that 10-page document with a lot of legalese, because I can assure you that 10-page document is not going to be favorable to you. And the reason why you don't want to have an employment agreement, a written one, is because the law provides some very extensive protections that are available to you. They're there whether you realize it or not. They're there automatically. But the law also allows you to give those rights away. And that is what an employment agreement usually does. It takes the rights that you would otherwise have and either gives them away completely or turns it around and gives them to your employer. And you may not realize you're doing that by signing that employment agreement. For example, there could be a term in that employment agreement that limits your severance substantially. That could cost you a huge amount of money. You can have a term in the employment agreement that allows the company to change your pay, change your job, relocate you. There could be a term that allows the company to lay you off temporarily. None of that are things that an employer is allowed to do unless you give them that right in an employment agreement. So believe me when I tell you, be glad and relieved that you have not signed an employment agreement. If you've signed one, you want to understand what you've signed. It's more than just your salary. It's more than just your vacation. You have to pay attention to other terms, because if you don't care now, you'll pay for it later.
Okay, fact number 2, just because there is a clause in your contract, like a termination clause, it does not mean it's enforceable.
So a termination clause is a term in an employment agreement that limits your severance. And employers are starting to understand that that's a good way for them to save money, so they include those clauses. The good news is that in many cases, in fact, in about 75% of cases, even if you sign the term that limits your severance, it's not enforceable. It's not drafted in the proper way to be enforceable. So maybe you've lost your job and you realize, wait a second, I limited my severance. I signed the termination clause in an employment agreement. Well, not so fast. In fact, that termination clause may not be enforceable, and that means you're still owed your full severance. That could be as much as 24 months' pay. That's why, Dana, it's so important. If you lose your job, you have to get advice. Doesn't matter if you're in a senior role or a junior role, whatever your situation is, always get that advice. You may be very surprised by your rights.
Okay, fact number 3, your employer can't make unilateral changes to your terms of your contract.
So your employment agreement, your employment terms are set. So just like you can't walk into your employer's office and say, hey, boss, I decided tomorrow you're giving me a 20% pay raise. That'd be nice. By the same token, your employer can't come to you and say, I've decided tomorrow you're taking a 20% pay cut. An employer cannot make substantial changes to terms of employment. And anytime that does happen, the term constructive dismissal should come to mind. If an employer makes a substantial change, you may have a right to treat that change as a termination of your employment and require the company to pay you severance. So if you are facing a change, before saying yes or no, before continuing to work or ignoring it and hoping for the best, let's talk. Give me a call. We may be able to get you compensation or maybe even get your employer to change its mind.
Okay, fact number 4, the company can't force you to accept a new employment contract.
So if you're already working and your employer walks in one day and say, hey, employee, we want you to sign a new employment agreement, that's bad news. Always, without exception. The reason your employer wants you to sign a new employment agreement, it's not because it's better for you. It doesn't provide you more rights. Remember, you're better off not having one. It's because it's better for your employer. It may have one of those termination clauses. It may have other terms there that are extremely problematic and costly for you. So the answer almost always should be thanks, but no thanks. I'm fine continuing with the way things are already. At a minimum, let me see that agreement. Let me tell you what it does, what it says, and help you negotiate it.
Okay, fact number 5, not surprising, an employment lawyer can review your contract and negotiate much better terms.
So you've just accepted a job. Congratulations. That's wonderful. But before you sign off on that offer letter, before you sign that employment contract, let's review it. Let's understand what it does. It's more than just your salary and your vacation. We need to know what you're signing, and oftentimes you can negotiate these terms. So don't sign anything without understanding what you're signing and getting some advice.
Okay, let's listen to another phone call for one of your live radio shows. Take a listen.
Mr. Samfiru, I was discharged from my job of 6 years about 8 months ago. The severance package I received was a little low, and I brought it up to the person who was presenting it to me. And they told me that because it was considered to be a layoff, that the severance would be lower, and whatever else was owed, I could actually recoup from the government through the employment insurance. Is that accurate?
So what are the differences between a termination and a layoff?
So you may hear the terms termination, layoff, dismissal, firing. None of those are having any difference. None of those really have any meaning. Really what matters is, did you lose your job? Forget what you call it. If you lost your job, you are owed severance. It's as simple as that. Doesn't matter if your employer called it a layoff or a firing. It doesn't matter. Unless you did something terrible that made it impossible to continue employing you, you are owed your full severance. There's no discounts. The company doesn't get to pay you less because they called it something that it's not. So bottom line is, if you had a job, you lost that job, you are owed your full severance. And as I said before, to find out how much you're owed, very easy to do. Just go to EmploymentLawyer.ca, use the severance calculator. You may get misleading information from your employer. Don't believe it. You lost your job, severance has to be paid.
Okay, Lior, let's take a short break. And when we come back, Lior from EmploymentLawyer.ca will discuss your rights in a corporate downsizing and being pressured to accept a termination. Stick around.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@EmploymentLawyer.ca, or visit their website, EmploymentLawyer.ca. We have lots more to discuss. Here's another call from your radio show.
I suspect my company may downsize in the near future. Been there for 6 years, and I'm just curious what I should do to protect myself, how I can maximize what I receive. What's the best step if I'm concerned about a future potential downsizing?
Lior?
So the thing to remember is that your employer can make the decision to let you go pretty much always and pretty much for any reason as long as they pay you the severance that you're owed. So there's really no way to change your employer's mind if they're dead set on letting you go. It's not possible. And in fact, the severance is something that the law takes care of. There's nothing that you need to do to maximize your severance. You want to have some relevant documents available because we'll need to review those. Your employment agreement, we touched on that. If there's a bonus plan or other policies that may affect your entitlements, let's have those handy, make sure you have access to those. Beyond that, it's just about making sure that when you are let go, you get the severance that you are owed. So that is the key here, and that is exactly what we need to make sure. If you lost your job, we'll get you the full severance. There's nothing you need to stress about before, and you can always go to PocketEmploymentLawyer.ca as you're preparing for it to make sure you get what you're owed. So let's do that for this person right now, and let's see how much he's owed if and when he's right and he loses his job. So we're using a severance calculator here, and we know that this person is 57 years of age. He's been there for 6 years. You can see that he's owed as much as 9 months of severance. So when you go to PocketEmploymentLawyer.ca, use the calculator just like we did here. You'll know how much you're owed. And then when you are let go, if you are, you can compare what you've been offered with what you're actually owed, and you'll know. If you've been offered a fair package, that's great. If not, you can contact me and we can make sure you get everything that the law says you should have.
Okay, let's shift to emails now. This one is from Chadwick. After I was fired, I signed the termination paperwork they gave me without speaking to a lawyer. After they kept pressuring me in calls and emails, I'm pretty sure that what they offered was far from what I should have gotten. Is there anything I can do about it now?
Dana, every single week I speak with 1 or 2 people in exactly this situation. They were offered a package, they felt the pressure, and by the way, of course there's pressure there because you're offered money and you feel like you have to accept it, you have financial obligations, you don't want to miss out on something. The problem is, if you sign that offer, even if it's completely inadequate, there's no going back on it. I can't help you, no one can. Once you've accepted it, that's it, it's a done deal. So that's why it's so important. As much as I know you're feeling the pressure, you get the advice before you sign it. Every single week I have to break to someone the news that, yes, you were owed another $50,000, but because you accepted it, I can't help you. Please, if you're watching, you know better. You're not going to let that happen to you. Get that advice always before you sign.
Okay, let's take one last break. When we return, Lior from EmploymentLawyer.ca will discuss your rights when you're headhunted by another company.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@EmploymentLawyer.ca, or visit their website, EmploymentLawyer.ca. Let's squeeze in a couple more questions, Lior. Here's one from Anne. I was heavily pursued and recruited from a company I had worked for 6 years. After only 7 months with the new employer, they fired me. They said I didn't meet their 1-year threshold for severance pay. Is that fair?
First of all, there is no such thing as a 1 year threshold, 1 week threshold. There is no threshold.
They made that up.
They made that up, or they're misinformed themselves. If you had a job and you lost it, you are owed severance. But this is actually even more interesting than that. If you're recruited away from another job, you're not looking, but you're recruited away, and then you lose your job shortly thereafter, you may be owed enhanced severance that accounts for your time with the previous company. So she may have had 6 years with the previous company, 7 months with this new company. For the purposes of severance, she may be a 6.5-year employee, and she could be owed 9 or 10 months of severance.
Wow.
We call this inducement. So reason 2045 as to why you have to get advice if you lose your job.
Good advice. Okay. Natasha sent this email to EmploymentLawyer.ca. I work for a large bank. Are there different rules for federally regulated employees if I lose my job?
So some employees are regulated federally, like bank employees, those in telecommunications, trucking, and et cetera. So your full severance is governed by the same rules as everyone else. Your minimum entitlements may be different if you're federally or provincially regulated, but your full severance are based on your age, your position, and the length of your employment. So whether you work for a bank, federally regulated, or a provincially regulated manufacturing company, it's not going to make a difference. There's a misconception that somehow federally regulated employees don't get the same amount of severance, get less severance. That's wrong, that's false. If you lost your job, federally or provincially, full severance is owed to you. The same rules apply.
Okay, Lior, thank you so much for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca, visit cp24.com/Ask a Lawyer. Join us again next week as we take a look at the rights of older workers in Canada's aging workforce. Thanks for watching.